Hey everybody, this is Rob Ryder. Sunday I went and did a little research on deeds of trust, and by divine intervention came across this one. And let's start with what it said in the lower right hand corner. This instrument filed for record by Commonwealth Land Title Company as an accommodation only. It has not been examined as to its execution or to its effect upon the title. So they're not saying it's been executed. That's very interesting when you talk about deeds, as I'm about to show you. But let's look at the rest of this thing real quick. Okay. Alright, so here's a deed of trust, short form. Looks like it has a recorded date up here. And then if you remember at the bottom it said filed for recording. It wasn't really recorded, it was filed, and I guess this is the file number. And it was filed into a record that already exists. So it wasn't recorded as a deed, however that's what it calls itself. And let's see what else we can see. We got a title order number and an escrow number. And then some standard verbiage that Edith Wynn was the trustor, and Orange Coast Title Company is the trustee. Now, Orange Coast Title Company isn't the company that had this filed. That was, I have to go back and look. It was a different company. And then some mortgage company is going to be the beneficiary. And, stop here. If you want to pause it for a minute and read it all, you're welcome to. I've already read it. So we come to the bottom and we see that Edith Wynn has sealed it, signed it, sealed it, subscribed it, whatever it is. And on the right hand side and on the left hand side we can see a certificate of acknowledgement that's done for Edith Wynn. So this notary is saying that Edith Wynn has done her thing. And normally you would find a certificate of acknowledgement underneath the signature. In this case, it's in the left-hand side in the area where the grantee should be seen. But we can see there's no grantee, nor is there any witness that the grantee has ever done anything with this. Well, with that, let's go look at an email that I sent out yesterday. Yeah, let me get back to the top page. So I sent this out on Sunday, the 27th of 2011, November 27, 2011. And since I've added a little bit to it, and I'll be sending this out as a separate package with the documents we're going to talk about to go along with this video. But let's see what this says. So we're going to see if we can make some lawful sense of the deed of trust. As you can see, I'm not going to read the whole thing. We're just going to kind of skim. In the paragraph stating, to protect the security of the deed of trust, trustor agrees by the execution and delivery of this deed of trust. However, whose execution and delivery, and have they done it? And then remember what it said. This instrument filed for record by Commonwealth Title Corporation and as an accommodation only. It has not been examined as to the execution or to its effect upon the title. So in my opinion, the instrument was never executed or delivered, and as such can be revoked by the grantor. And there's a sample of a revocation of trust at the end of this, and then a deed of revocation that I came up with we'll talk about later. Now, some of the brothers and sisters who have gone to accept their deeds or acknowledge their warranty deeds have been told that a deed is a deed is a deed. Well, in that case, then the grantee has to accept and acknowledge the deed, and they have not. It has not been delivered or executed as stated above, has not been examined as to the execution. In fact, a different title company filed the record, so Commonwealth Title Corporation filed the record, and the listed one is the Orange Coast Title Company. I may have that wrong. I think Orange Coast Title Corporation is correct. Now you go back and look. One's a company, the other one's a corporation. But where's the proof that it was ever executed or delivered? And so it said it was an accommodation. Well, as a term used in United States contract law under the UCC, statute law, fiction, to describe delivery of non-conforming goods meant as partial performance of a contract for the sale of goods, where the full performance is not possible. So for one reason, that full performance isn't possible to do. So they did a partial performance. It's also a favor done without compensation, such as a signature guaranteeing payment of a debt, sometimes called an accommodation endorsement. It's not a very smart business practice, since the holder of the note can go to the accommodator rather than the debtor, and will do so if the accommodator has lots of money or is easier to locate than the debtor. So we don't necessarily know where the mortgage company is anymore, but we know who accommodated it, a title company. So we'll go talk to them. Okay, and everything else after this, most of it has come out of this book. This is the Google book. This will be a link that you can link to, but it was called The Real Property Law of the State of New York, being Chapter 50 of the Consolidated Laws. It was passed February 17, 1909, Chapter 53, Laws, 1909. The author is Robert Ludwell Fowler, and it was the third edition in 1909. And I started on about page 814, which is conveyances and mortgages. A grant of fee or freehold. A grant in fee and freehold estate must be subscribed by the person whom the estate of interest is conveyed is intended to pass. So the person that is intended to pass to must subscribe the grant. It's not on there. The notary did not represent, isn't a representative of the company. It did not call themselves an agent. What did the notary say? Really, all the notary did on here is they're just acknowledging Edith Wynn as the grantor or the trustor. Has nothing to do with the trustee or the beneficiary. Every grant in fee or in freehold estate must be subscribed and sealed by the person for whom the estate or interest conveyed is intended to pass. So they got to subscribe it, which is sign at the bottom, or they have to seal it. Again, they're not on there anyplace. The statute of frauds, according to Blackstone, my hero, Mr. Blackstone, kudos to you, first made signing essential to the validity of a conveyance of a freehold inter vivos. Well, we're alive, and we did this, so it has to be, signing is essential under the statute of frauds. Because this particular part is statute law, this is the fiction we're talking about. This deed of trust is fiction. In fact, when you read that deed of trust closer, it'll talk about a fictitious deed of trust from 1961 or something like that. Subscribe to right name at the end of a writing. Again, that's what the beneficiary is supposed to do, or his agent, and they haven't done it. Both at common law and under revised statutes, a conveyance of freehold estate must be sealed to be effectual. Now, they're saying that even under revised statute, it must be sealed. There is no seal for the beneficiary or the trustee. Attestation and acknowledgement. Neither attestation or acknowledgement is necessary to the validity of a conveyance inter partes, but only to effectuate it as to subsequent purchasers or encumbrances. Proof of delivery by subscribing witness. This section provides that if a deed is not duly acknowledged before it is delivered, its execution and delivery must be attested by at least one witness. Again, there's no witness. Look at yours. You find me a witness for the beneficiary. The reader will observe that execution is treated as separate from act of delivery. This statute contains very dangerous requirement, for if the subscribing witness forgot the factum of delivery, it seems the record of the deed so proved by him may fail as to subsequent purchasers or encumbrances. Proof of actual delivery deed is no doubt too much neglected by conveyancers. They're talking about you. Where's the proof of actual delivery? They can't spell it out any clearer, people. The witness often sees the subscription of the grantor, sometimes the unsealing, which are sum and substance of the legal term execution. But the actual delivery of the deed in his presence is either neglected or not sufficiently emphasized to enable him, and a question arises long subsequently as to the priority of the deed proved by him to swear positively as to its delivery in his presence. And a little drum roll, please. Indeed, the fact that a deed is signed by an attesting witness in a common form prescribed in the usage of the state's by usage in this state, generally negative proof of its actual delivery before the witness signed his name. So how could he have given it to them, and then he has to give it to them and then sign that he has? Again, there's no proof of delivery. In connection, it may be said that an attestation by subscribing witness where a grantee does not acknowledge the execution before a notary to the effect the deed is signed, sealed, and delivered in the presence of the witness is a better formula than simply in the presence of the witness. So in connection may be said that an attestation by subscribing witness or the grantee, okay, so there is no attestation. There's no witness or attestation saying that they acknowledge this for the grantee. It should be stated that a deed, after it's signed and sealed by a grantee, was actually delivered to the grantee in the presence of subscribing witness. This is certainly a safe precaution when a grantor fails to duly acknowledge a deed and its validity depends on its proof by witness, such as the agent usage of proof delivery of cessation before deeds were essential. Now, to me, they're saying that even though it's a statutory deed, it said it had to be sealed. Well, for it to be a public record, and for you to be liable, number one, not only did you need to have this certificate of acknowledgement from this notary, but you had to get the notary attested to, just like we do for acknowledgments. If we're going to acknowledge something, we need to make sure that the person that is witnessing, in this case Gerard Bachman, has an oath on file. And in California, you would go to the county recorder and ask them for it for this guy. Wherever their oath is out of, this guy's Los Angeles County, you would go to Los Angeles County, the county clerk, and ask for a certificate of authority. Same in Michigan. Now some places, if you're using a notary, you have to go to the Secretary of State. My point is, this doesn't have a certificate of authority unless it's another page to this document that I don't have. I only had the front page, so look at yours, and I'm quite sure you didn't do it, so it didn't happen. So you didn't do a lawful conveyance. Not effective sealing. Notwithstanding, a conveyance of lands need no longer be sealed. Conveyancers prefer to seal them as to not to experiment with the essential presumptions of the law of covenants running with the land. So apparently, we have this covenant that runs with the land as part of our birth registration. And it must say that conveyancers prefer to seal them as to not experiment with established presumptions. So they're presuming that whenever we use our signature, it's actually our seal as the living man. And that's part of the covenant that runs with the land. That's how you convey real property. And yet a seal is still regarded as imputing solemnity and efficiency to the instrument, though not for the purposes of specific performance and equity. A recital of seal is not, however, equal to a symbolic or substitution seal. Formally, a seal on a deed leasing a larger liquidated debt on part of payment of the same operated to make discharge good And this is probably still the law, although the statutes making consideration of sealed instruments rebuttable somewhat disturbs the principle that a liquidated debt cannot be discharged by payment of a part of it unless the release is sealed. A common law, an instrument under seal, could be released only by an instrument of a higher nature. But an early day of this rule was much modified in this state. But even now, only parties to sealed instruments may sue or be sued on them. Okay. A lot of interesting stuff that doesn't have to do with the main point of what I'm trying to get to. First they say that a seal isn't required in parts of this, and other parts they say they do, or that they are. A conveyancer now requires a consideration to support it. And a seal remains prima facie or presumptive evidence of consideration. See, there's two kinds of consideration, valuable and good. And good consideration is done by blood or affection. Has nothing to do with handing over any dollars or anything else. It's just by blood or affection. So good conveyance is actually better than valuable conveyance, or good consideration is better than valuable consideration. And since they're saying that we've used our signature as a seal, we've given good consideration. Consideration, while a common law, a deed or an under seal always imported a sufficient consideration in it, was otherwise. To deeds operating by transmutation of possession, a consideration even after statute uses was unnecessary. But a bargain and sale and covenant to stand seized after the statute, as before, it in courts of equity required a consideration. And we're going to find out that this is considered a bargain and sale. Bargain and sale is operated by force of the uses, and as before, the statute's equity would not enforce bargain and sale without consideration. This notion was transplanted to the common law courts after the statutes of uses. Bargain and sale still require a consideration to support it, and a covenant to stand seized is still supported only by consideration of blood or marriage. That the consideration should actually express in the conveyance of a deed is not at common law, and it is not now. Sorry guys, I'm having a hard time reading this. When you translate this out of a book, it doesn't put any of the punctuation in. But when sealed, such instruments are only prima facie founded on sufficient consideration. The Anglo-American or common law doctrine of consideration, when applied to deeds of conveyance, is an obscure subject and in modern times somewhat dependent on the growth of the doctrines concerning actual contracts. Since the abolition of the feudal system, the tendency of law is to regard conveyances as a contract, though originally a conveyance was probably a law of status and not the law of contract, which it was, because only landowners could do deeds to convey land. And that's what you are. You're a landowner. Your body's land. It's been registered, but it's still land. So let's see here. Under ancient conceptions of status are subverted and the modern doctrine of contract elevated, we are sure to find that the doctrine of consideration grows. Thus, in modern law, it is probably better to adopt Blackstone again, who says that every deed requires a consideration to support it. Such is the tendency of cases cited above, and especially in equity, for in that form a reconveyance will even be decreed if the consideration of conveyance fails. So where is their consideration for us? They didn't seal anything. There is no consideration. Had they put a seal, that would be considered consideration. But the only one who sealed it is the person that witnessed us, not them. What is true of deeds of conveyance not under seal, for they are clearly to be treated on the basis of contracts and therefore dependent on the enforcement of the doctrine of consideration. Now remember, deeds are used for two things: conveyances of land and contracts. So when it's used as a contract, which is what they're doing now, this wasn't recorded as a deed. It was recorded as filed with a deed, and so it's really a contract. Nevertheless, a deed is a deed is a deed. And we're going to write ours as our free will act and deed, so we're going to call ours a deed. We'll continue on. Besides, the modern conveyance referred to in this section of the Act is regarded as the equivalent of a bargain and sale, which we have seen always has required a consideration to support it. Fraud avoiding deed at law, deeds may be avoided at law for fraud in the consideration or for fraud in the execution. In the equity, the jurisdiction is even more extended. In equity, the jurisdiction is even more extended. Now, all this is coming out of the section that's under mortgages. A grant must either be acknowledged before delivery or its execution and delivery attested by one witness. Again, they haven't done either. So, where is the witness attesting to the execution and delivery? When statute requires a deed to be sealed and recorded in order to operate as notice, and the record shows no seal, it will be presumed in an action of instrument, at least in the absence of proof to the contrary, that the original deed was sealed. So, until they're going to say, by presumption, that because it's recorded, it's been sealed, unless you bring in proof to the contrary. And we'll do that. When a grant takes effect so as to vest the estate or interest intended to be conveyed only from its delivery. So it has to be delivered before the grant takes effect, and apparently it hasn't done that yet. Grants, like all other deeds, had no effect without delivery. They're just spelling it out. I'll stop there for a second if you want to read the whole thing. And this is in that book. Just go download the book and start reading. Since the revised statute, deeds of conveyances or grants take effect only from delivery of the deed to the grantee or to another for use of the grantee. So, since the revised statutes, deeds of conveyance or grants take effect only from delivery of the deed to the grantee. So again, this is in a section of the book about conveyances and mortgages, and we've done a grant that those words are used in the deed of trust, but until it's been delivered to the grantee, which means he has to acknowledge the deed, or a witness has to come forward and say that it's been executed and delivered, and we have on our deed of trust that it was filed, but they're not saying it's been executed. So, the big drum roll. Delivery to a third person. Again, remember, this is delivered to a trustee, right? We're doing a deed with a trustee for the benefit of somebody else. Delivery to a third person, or conditionally, while deeds of conveyance may be delivered to a third party in escrow, they may not be delivered conditionally to be party to a deed. They may not be delivered conditionally to a party to the deed. The deed may be delivered to a third person in blank, or to be delivered to a corporation to be formed, or the deed may be so delivered to take effect on the grantor's death, or otherwise, until which the delivery is revocable by the grantor. So, this shows that it went to an escrow. There's the escrow number. And we ain't dead. And since it's gone to a third party, and we're not dead, the grantor can revoke the trust. Delivery of a deed to a recording office is good delivery if ratified by a party benefited, unless such deed was contrary to the grantor's intention. Well, again, it hasn't been ratified. Presumption of delivery. When a grant is attested, there is a presumption of its delivery, and it's presumed that it had been delivered in its date unless acknowledgement is subsequent thereto when the date of the acknowledgement is to be presumed as the date of delivery. So they've not acknowledged it. It hasn't been delivered. You put your paperwork in first. You're first in line, first in time. First in time, first in line. Ratified means formally approved and invested with legal authority. So recording the deed furnishes presumptive evidence of a delivery and a record by the grantee. So rebut the presumption. Where's the witness attesting to the delivery? Proof of delivery. When a deed is proved by a subscribing witness, the importance of actual delivery should be attested by the witness and carefully preserved. So they better have a record. So since here it said until which delivery is revocable by a grantor, what's revocation? Bouvier's. The act by which a person having authority calls back, annuls a power, gift, or benefit. And so the same process will apply to revoking the deed of trust known as the vital record birth certificate, and not to be confused with the certificate of live birth or the certified copy of record of birth. These are all the same documents used for real property, which is your body, to what we're dealing with in real estate, which is the public land. And we have a land patent for our body. We have a owner certificate of title. And there's a deed of trust involved. So there's a few things we need to do. More on that later. But let's just do the real estate today, because if you want to get your money out of the escrow, it may be possible. So I found this online. This is called a revocation of trust. And I'll stop there for a second and let you all read it. And if you want to use this, you're going to stop the film or write it down, go back and type it, print it, come back and look at it, make your corrections, and then you'll own the words. But this is what somebody came up with for revocation of trust. And so you can see at the bottom here is the certificate of acknowledgement that you need to have done. And anytime you do a certificate of acknowledgement, I highly recommend that whoever the officer is that does it for you, that you go and get their certificate of authority to make it a public record so it has full proof evidence, full faith and credit of the Constitution, Article 4, Section 1. So this was somebody else's idea here, and this is how I would do it. Again, I don't know any property, so I don't know exactly how I'd do it. I just started putting words on paper. Let's see what I came up with. I'm going to call it a deed of revocation. I want to call it a deed. I want mine recorded as a deed, a common law deed. I'm going to have myself as a witness, a notary as a witness, and the notary's boss or the certificate of authority, whoever gives me that, under their seal as a witness. And this is kind of how I write. So if you've not seen this before, you may not be used to it. So revocation of deed of trust by grantor for lack of execution by beneficiary. Given the name Robert Allen by the Father, I am an immortal living soul created in his image. Here is one of his people, a living man. Under the seal, Robert Allen Rytlewski, am the lawful owner of the landed estate known, the landed estate, all caps, my all caps name, and its real property and interest. So if you didn't know, your first and middle are your given name. They were given to you by the Creator. They're a gift. Some people call them a Christian name. Anytime you add your surname to that, you've diminished the power of your given name. The Creator gave you the name first and middle. Why are you adding to it? And then I tell them that my seal is my signature, Robert Allen Rytlewski. If I put that down that way, that's my seal. And I'm the lawful owner of the landed estate, Mr. All Caps, because it is a landed estate that was carved from the larger estate, which is your body. Whether it's a drop of blood or whatever they did to create this lease that we gave them, it's been done. I accept the oaths of all lawful officers and bind them to it, and in return extend my sovereign immunity to carry out this lawful order. So, again, I'm going to make this a public record, full faith and credit of the Constitution. And so I'm accepting the oaths of all lawful officers because oaths are written as common law deeds. The grantor was the man who took the office. The grantee is the public. But if you haven't learned by now, you must understand that the grantee must accept the deed for it to be lawfully executed. So when you accept a lawful officer's oath, now they're bound to it. Otherwise, they're not. He's made the offer. You have to accept it. So I'm using this lady's deed that I found online as how I would do this. None of this is real. This is just ideas, right? So as trustor, I sealed a deed of trust naming Orange Coast Title Company as trustee and Pacific Shores Realty and Mortgage Incorporated as beneficiary on July 26, 2005, witnessed by Gerald Bachman, a notary public. The first page of the deed of trust and the signature page are included. So I don't know how much of your deed of trust you need to give them to get the information that they need. The whole thing's already on file anyways in your case, so or in your property. You may just put the property book and page number, and they can go look at that. If you want to attach the whole thing, that's up to you. Don't ask me. Go try it and tell me what works. Evidence of said deed of trust can be found in the County of Los Angeles Register of Deeds Office, filed for record 8/17/2005, file number, that number, by Commonwealth Land Title Company. Further evidence is the title order number and the escrow number. So, really, I'm just taking this information here, the file date, the file number, the name of the company that asked for it to be filed, and the name of the notary who witnessed my signature seal. So under the lawful powers of the trustor, grantor, of this modern statutory deed of trust, I revoke said deed of trust due to lack of execution and or delivery acknowledgement by the beneficiary or his agent. The beneficiary shall acknowledge delivery of a deed of trust, and until then the trustor has the power to revoke. I have executed that power here, now, today. Therefore, all rents, issues, profits, and right and title that are the beneficial interests of this deed of trust are to be immediately reverted absolutely to me in the name of my landed estate. I further declare the trustees of said deed of trust free and discharge from any further responsibility of administration and management of said deed of trust and the principal thereof. My wish to revoke said deed of trust is now a matter of public record, as my free will act and deed, witnessed under my hand and seal, and lawfully acknowledged and attested to with full faith and credit guaranteed by Article 4, Section 1 of the United States of America Constitution. I don't know what else you need to tell them, so I'm going to sign off there. I'm not going to tell them any more than I have to. The more you write, the more you constrain yourself. But I'm telling them when I do this, it's as my seal. And here comes a certificate of acknowledgement. Right? So now you're going to go to the notary. They're going to fill this out. The state of Michigan, the county of Kent, on this, whatever day it is, of whatever. And that 13 should be out of there. Before me personally came and appeared, whomever, me. And I would put my seal, Robert Allen Ralewski, because that's my seal. That way they don't have a problem with it. It looks okay to them. I've already told them what it means up ahead, and it's not up for them to decide. That's my free will act and deed. Yada, 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 yada. So, and then they're going to witness it, right? And so you must get a certificate of authority for the notary to make this lawful public record act and deed. Then have this recorded with the Register of Deeds as a deed. Send a certified copy to all interested parties. And of course, you're going to remove this blue part from your document. Now, I think that's how to do it. I haven't really thought it all the way through, but the rest of it is just out of a law book saying what's going to happen. So I really want to get this information out and let you sharp tax figure it out. What is the document we're going to use to quickly and immediately get back our interest that has gone into these deeds of trust? Because the grantee has never accepted the deed, and until he does, we have every right to revoke the deed. It's in their law. Don't argue with it. So listen, I'm going to leave it there and get this thing done so it's not too long. Again, my email is courtofrecord@aol.com. courtofrecord@aol.com. And I'm Rob Ryder. It's great talking to y'all. Let's go get them. See ya.